Welcome back. And we have Ledge Council number 2 with us. Nice to see you, Eric. We we very rarely get to see you.
Oh, well, thank you. Nice to see everybody here too. Does seem,
House help.
thanks so much. Eric Fitzpatrick with the Office of Legislative Counsel. Good to see everybody. It is hard to believe. I can't even remember. It seems like it wasn't that long ago, but it probably was. Yeah. Time flies when you're having fun.
Yeah.
But it's also funny that Katie was up here, right, doing her portions of this bill.
Yeah.
I was down in House Corrections and Institutions, and then we just switched. She's down there and I'm up here, so glad to be here and happy to walk the committee through. I think I had a chance to talk with Katie for a minute. You know, the bill is pretty well divided, like the first, 60–70% of it is my pieces that have been dealt with in first Senate Judiciary, Senate Corrections and Institutions, Senate Health and Welfare on that side. And then up here, being looked at in House Judiciary, this committee, also Human Services and Corrections and Institutions. So, happy to chat with the committee about any portions that you think you're interested in. But also, just so you know, the Judiciary Committee at least has really been focused on the first, like I said, 60% or so of it. Not that they haven't looked at the rest, but Katie may have already walked you through a bunch of that.
We could add some money in fees so it could go to Ways and Means and Appropriation.
Yeah, right. Yeah, that's a good idea. Keep it kind of among one committee and another. Sorry, you got quite a few, so might as well have the rest.
Yeah.
Right. So I'm sure Katie explained the big picture to you, but is there anything that's sort of off the top of your head, at least before I start talking about the big picture, that you were sort of deferring? Maybe let's hold that question, but you really want to know this before we even get started? Or should I just kind of describe what the big picture is?
Yes, go ahead.
Maybe, but very quickly,
Yeah.
where are these people today?
Oh,
That's a good question. So the universe of people who would be covered by this forensic facility proposal. Some of them might be held at corrections facility now. Some of them might be out in the community. Some of them might conceivably be, although it's difficult to say for sure, but they could be hospitalized. I always seem to have a trouble with that. Hospitalized. I got it that time, I think.
you got two easies in that.
Yes. Yes. So that's where they could be now.
Okay.
And could you say how many we're talking about?
Well, there's been sort of anecdotal testimony, at least, that it's about 6 people a year, roughly. I don't know that is a definitive determination, but it's roughly what there has been so far.
Like 6 new people,
Yeah.
or is it cumulative? I mean,
I was a little unclear on that myself.
okay.
Have you discussed competency restoration and the variance between the IDD folks and the folks with mental illness? That may have some bearing on the turnover.
Not in the context of the numbers. No, they haven't talked about it in that respect, I think. But yes, it's come up in terms of at least House Human Services, for example, being particularly concerned about whether the IDD folks are appropriate for this sort of setting at all. So it's been talked about in that way, but not sort of as a way to whether that might affect the computation of the number of people who are.
My understanding is this is majority folks with mental health issues versus developmental disabilities.
I understood that as well.
Okay.
I don't have any data really to back, but that's what I thought.
Mean someone with IDD who's committed a crime? Is that what we're talking about?
Or
Sorry, my last question, and I don't know if you're gonna know this, Eric, but someone else on the committee might, to remind me, I know we did something with changing things at River Valley. So does that encap people?
if I recall from our discussion with River Valley, and we asked, but we'll ask
Tomorrow.
Yeah, TMH when but remember, forensic people, for being held for forensic are not eligible for any sort of like Medicaid or,
Right.
sort of reimbursement, federal funds. And I think I recall Emily might have said no one ended up going there because
That.
of that.
And that
You're absolutely right.
had something to do with it being a locked facility. But what you might be thinking of, Lori, is that we added EIPs, the emergency
Yes.
involuntary procedures to River Valley.
Yep.
And that was, to my understanding, intended to help find a home for these folks.
That's what I thought. Okay, so we'll ask tomorrow. Okay, I'm done. Thank you.
Val. I got it.
Oh,
I didn't know
okay.
IDD was.
Oh, yeah, we've been trying to, same, we've been.
Eric, you want to give us the big picture
Yeah.
again, because we're probably going to need the big picture.
Happy to. There's a lot of weeds in this bill. If you just take one look at it, you're like, whoa, there's a lot of legal language in there. So it's easy to get lost in the weeds. It's helpful to have the big picture kind of in the back of your mind to understand what all these details are talking about. So Representative Hawkins asking about what happens now. Helps to think about for a moment what you have in place. You do have in place a legal procedure for what happens when someone is found either not guilty by reason of insanity or incompetent to stand trial as a result of a mental illness. That procedure is that if that person is found dangerous to themselves or others, a legal terminology for that is person in need of treatment, that person is found by a court to be dangerous to themselves or others, they get committed to the Department of Mental Health for treatment. Now, that could be an order of hospitalization, it could be an ONH, could be either one of those things, but they would be within DMH custody if the court
ONH?
order of non-hospitalization, right? Could be either one of those. If you think about that universe of people, though, it depends on the existence of a mental illness. That's the current. So what other non-covered situations might that current system leave? Well, anybody who might have been incompetent to stand trial or not guilty by reason of insanity for a reason other than a mental illness. That's not covered by that existing structure. In addition, someone could be, as I just mentioned, committed to DMH. There's a mental illness at the time. But it could be that the DMH might find that person is not clinically in need of a hospitalization level of care. So that person, again, order of non-hospitalization could be the result of that, some sort of community treatment. Again, that's not related to the person's dangerousness. It's a clinical determination that might leave that person in the community. So that's another universe of people that could be covered by this, because that's a person who would be dangerous, but they're not subject to a hospitalization order. And so that can happen while the person is within DMH custody currently. They could end up potentially being subject to the forensic facility procedure that's in S-193 if they're not hospitalized any longer.
Where in this continuum are people who have not yet been deemed not competent to stand trial, but are in this sort of limbo, trying to restore competency? Where are they? Who are they under the custody of?
Well, there is no formal competency restoration procedure in Vermont currently. No formal, which is not to say that that sort of process might not be taking place in some way. But if there has been no court finding that either the person is not competent to stand trial or not guilty by reason of insanity, then that person could be at the Department of Corrections. They could be, if they were found in the process that I just described, the civil process, that they were dangerous to themselves or others as a result of a mental illness, they could be in DMH custody, either in a hospital or on an order of non-hospitalization. They could be, or they could be released, but conceivably, because a person can't be, there's constitutional requirements on holding a person without bail. If they've been charged with a serious crime, if it's not a serious crime or there's not a great evidence of guilt, then the person could conceivably be within DOC custody, but in the community, not necessarily in an incarcerated setting either. They could be out in the community, conceivably getting whatever treatment they needed as they were awaiting trial.
Can you speak to where we're at with victim notifications? Because I know that's an
We have
element in
questions.
this bill, but we also did stuff in S 54, 3, a
Yep.
couple years ago.
Yep, and those are really related to, there's a lot of victim notification procedures in the criminal law in general. So the victims have a lot of rights to be notified about when there's going to be a hearing with respect to the criminal charges. They have the right to be there to present a victim's impact statement. They have a right to be heard. And there are, within the context of the type of proceeding that I just described, the Department of Mental Health proceeding, dangerous to self or others as a result of mental illness. That's what I think you're thinking of.
Yeah.
They have rights specifically in that procedure as well. So they have all these existing rights in other procedures, some of which will be related to this procedure. And by that, I mean earlier on the timeline, like they're in court, they've been charged with something criminally. They haven't been found incompetent yet or not guilty. Have a right to be at those proceedings and notified, make a statement, that sort of thing. This particular proceeding is being created. So they are also crime victims are also being provided with the right to make appearances and statements at these proceedings as well.
I see.
So it's sort of a parallel.
So currently, we do allow victims to make a statement during proceedings, even if someone is not. No, there wouldn't be a proceeding if they're not competent to stand trial, right?
There would be competency proceedings. Yep, there would proceedings about, for example, if the court finds a person incompetent, they have to have a hearing. And at that hearing to determine whether or not they are dangerous to themselves or others, because if they're dangerous, then they get committed to DMH. If they're not dangerous, well, they're not committed to DMH and they can just be treated and released. If they ever are restored, and that's one of the huge fundamental differences between competency and not guilty by reason of insanity, is competency can be restored. So someone who's found incompetent to stand trial, their criminal charges aren't dismissed necessarily. Prosecution could do that, but not necessarily. And if it's a serious crime, it certainly wouldn't. And whenever that person's competency is restored, then the criminal case can go forward. So, so there will be proceedings sometimes that continue on, and under that existing law, victims have rights to appear and make statements. And you'll see as we get to it, maybe you saw it already, that there are, and in fact, in response to a request from the Center for Crime Victim Services, there's language added in here specifically about their ability to make a statement during these proceedings under this new court process.
How many other states have forensic facilities?
Most. I don't know exact number, but most states have one.
That's a silly question. So if somebody, is restored,
Yep.
is there a possibility that statute of limitations for the crime they have committed could?
It is possible, yes.
Yeah, okay.
Yes. But there is a provision in the general criminal law that provides for, under certain circumstances, the statute of limitations is told. So it pauses. It's kind of like when someone's a minor. Statute of limitations doesn't run if someone's a minor for purposes of it being charged with a criminal offense, because you can't be charged with a minor. They could be charged with a juvenile offense, but not a criminal. If someone is, I think it uses the word, yeah, I think it's an old statute, so I think I might use the word insane or something like that rather than incompetent. But it's that idea. It often won't run.
Okay.
Because a person can't be charged criminally, so they kind of put the SOL, which is shorthand for statute of limitations, on hold until the person regains.
This might have been a better question for Katie. I'm not sure. But maybe you can help out with it. In section 1, the last G, it's basically on page 8, starting at the top.
Yep.
So this involuntary medication order. I don't know how it differs from what we have currently in various other realms, but I'm guessing it probably is much different. Do you know like how this would differ of what the court must find in this particular case? How would that differ from any other involuntary medication areas that we have in law,
Right.
the requirements that must be met?
Numbers 2 and 3 are specific, and those four standards, lines 5 through 13, are right out of a United States Supreme Court case that's specifically providing for when it is that involuntary medication can be administered in the context of restoring somebody's competence to stand trial. So it's very specific. And the court specifically said, you see, well, numbers 1 and 4 I think would be generally true for involuntary medication, but 2 and 3 are specific. Involuntary medication has to serve the important governmental interest of bringing to trial an individual accused of a serious crime. So in other words, the idea is to bring that person to trial eventually. And number 3, the involuntary medication significantly furthers these important governmental interests by making it substantially likely to render the defendant competent to stand trial. So the whole idea is to restore the person's competency so that they can then stand trial. That has to be the standard in context for involuntary medicine.
Basically, in layman's term, and what's being read here, that you can effectively drug anyone voluntarily if the government has an incentive to get them to stand trial and as quickly as possible.
Well, I think 1 and 4 also apply. Has to be medically appropriate on number 1. And number 4, alternative, less intrusive treatments are unlikely to achieve the same result. So you kind of have those standards, blanking on the right word, but those standards are also existing in addition to the specific ones that you were mentioning.
And those standards are determined by the court, not a clinical determination?
Typically speaking, in a situation like this, the court relies on expert testimony. So yes, final decision to the court, but they don't make those sorts of decisions that require expert testimony in a vacuum. They generally have to require qualified expert.
And when it says the commissioner shall, we're talking about the commissioner of corrections.
Yes, okay, exactly. So big picture again for a second. We were talking a little bit about the universe of people who aren't covered by current law, who this is supposed to cover. And the idea is, again, think for a moment about, there's 2 avenues by which a person could get to the forensic facility, but they're both forensic in nature. They're related to criminal proceedings. What I was talking about earlier, the DMH process, that could be criminal, but it's also not. Family division covers situations where, for example, a family member, if you think could be dangerous to themselves or others, you can go with a health professional to the family division and get an order of involuntary commitment to that person. It has nothing to do with the criminal process at all. This only applies to people who are in the criminal process and someone who's been charged criminally, and at least with respect to competency, if you look at page 1, not just anybody who's been charged criminally, has to have been line 14, page 1, charged with a life sentence offense. So very serious, only between 10 and 15, depending on how you look at it, offenses does Vermont have with a lifetime max. Relatively small number. They have to either be held without bail, which also, generally speaking, is a lifetime offense, and there has to be a significant amount of evidence of guilt. Or if they're not held without bail, then there has to be a determination that they would be dangerous. That's subdivision B. Subdivision 3, they're not currently receiving treatment. They're in order of hospitalization. So in other words, they're not already in that civil process getting treatment through hospitalization that way. So they're not going to get. So they're not in that context either, and they're found incompetent to stand trial. Okay, so that's just one group that could end up at the forensic facility. As I just said, remember something unique about that group is that competency can be restored. So competency has to do with the defendant's mental health status at the time of trial. Nothing to do with their mental health status at the time of the criminal offense, the time of the trial. And if they're unable to understand the nature of the criminal charges against them, or if they're unable to participate in their own defense, that's what incompetency to stand trial means. But it has to do with the trial. And so it's sometimes referred to as a transitional process in the sense that it can be restored. You can be competent at one time, and whether through mental health treatment, medication, time, whatever it may be, your competency can be restored. And if that happens, then the criminal case can proceed. So the criminal court continues to have jurisdiction over you. It's an important thing you'll see when I get to group 2. Criminal court has jurisdiction over the person because there are pending criminal charges, right? The charges are still there. So that's this one group that if we meet those criteria that we just talked about, then they will be remanded to the forensic facility. Group number 2, not guilty by reason of insanity. Very different than incompetent to stand trial. That has to do with the mental health status at the time of the criminal offense. Nothing to do with the time of trial. It's at the time of the offense. You either could not understand that your conduct was criminal, or you were incapable of conforming your conduct to the requirements of the law. So in other words, even if you did understand that what you're doing was criminal, you couldn't control yourself. You couldn't conform your behavior to the requirements of the law. So either one of those two things are true, and you prove that. It's a defense. That's the other thing. It's a defense. Now, competency is a threshold issue, so that, the court, the prosecution, the defense, anybody who thinks that the defendant is not competent, they will raise it, and because it's unconstitutional to put on trial someone who's incompetent. Can't do it. So on the other hand, not guilty by reason of insanity is a defense that the defendant can raise. And if they prove it, and typically the way it's proven is the defendant says, yes, I committed that act. I committed that conduct. But at the time of the offense, I was criminally insane. I couldn't understand that what I was doing was criminal, or I couldn't conform, I couldn't act in a non-criminal way. And that is a complete defense. So in other words, case dismissed. You can't ever be charged, because that has to do with your mental state at the time of the offense. That means the state will never be able to show that you had the required mental state, what the law calls the mens rea, the mental state that was required to hold somebody, basically imprison somebody against their will for criminal conduct. So that can never be changed. So the state can never bring that criminal charge again. It's done. So that's a different situation, because the state, in that case, the criminal court doesn't have jurisdiction over the person anymore, right? Case is dismissed. So that poses a different issue, and has to be addressed, because how does the court send somebody to the forensic facility when they no longer have a criminal charge pending against them? That's come up, as you might expect, in the United States Supreme Court, had to deal with that exact specific issue. Is that constitutional, or is it a due process violation? And the court said it's okay. As long as the person is both dangerous, state has to be able to prove that they're dangerous, and that the dangerousness as a result of this mental illness, this mental health condition. It can't be one or the other. It has to be both. That's kind of your overlay. That's the big picture. And those are your two tracks under which somebody can get sent to the forensic facility, but their treatment is different because, as I just mentioned, court's authorities are different with respect to each of them. And you're not going to ever, the person who's not NGRI, not guilty by reason of insanity, is not getting competency restoration services at the facility, because they're not, that was irrelevant. Their competency is not a question. They can never be charged with that crime again, so there's no reason to restore that competency.
Isn't there a point, and Brian, I see your question, isn't there a point though, however, in the not competent to stand trial where it's acknowledged that competency can never be restored and then charges are dropped? Or, do they always remain under the jurisdiction forevermore?
No, not necessarily. And you'll see the bill sets up a series of kind of forks in the road where they have to look at that question of restorability. And first of all, the state, no one has to be, someone could be found incompetent for stealing a pack of gum, right? It doesn't necessarily a serious criminal offense. And the state can just not bring those charges or drop them. It's always an option. This, as I mentioned at the beginning, this is only applying to some very serious offenses with lifetime maxes. And within this context, there is steps along the way where the person has to be released eventually. So, and that's also a constitutional requirement that the US Supreme Court has kind of laid out there, which is to say, yes, you can hold a person in this situation, but it can't be forever without some finding of dangerousness. And so you'll see, I can sort of describe it, that at several steps along the way, and it's periodically, there are reevaluations every 6 months, every year, or whenever the person demonstrates that they may be competent again, the court has to have these reevaluations. And if one of these reevaluations, the court finds that the person is not dangerous, then they get released. Subject to conditions.
Brian?
That's the idea. Anyway,
So I have two questions that might also generate another question.
Yeah.
So it's unconstitutional to force someone to stand. If I misuse the words too, you can correct me, because
Sure.
this isn't our usual focus. So I might not have the right terminology, but it's unconstitutional to force somebody to stand trial if they're deemed incompetent.
right.
But it's not unconstitutional to detain a person who isn't guilty, who hasn't been proven guilty yet, in a setting where they're being essentially punished and staying alongside others who have been convicted.
Yes, I guess is the short answer to that.
Because in Vermont, we detain people in the same facilities and treat them the same as the ones who are sentenced. So if this forensic facility is in a correctional setting, then essentially it's compounding the problem that already exists of us treating people as if they're guilty before they've been even proven guilty.
That part's not for me to respond. That's a policy decision.
Am I wrong that that's happening?
That description that you just gave is not something that I can comment. I can comment to you on the legality of what it is that can be done under this procedure. The court has specifically said that if the person is found incompetent to stand trial, which means you're right, there was never a finding of guilt. That person, if there's a finding of dangerousness as a result of a mental illness or associated condition, that person can be held. As far as whether sort of the circumstances of that holding is kind of what you're
Right, so
extrapolating from that.
Currently, when that happens,
Right.
you're hospitalized.
Not necessarily.
So there's people incarcerated for mental health conditions solely in Vermont. Because I thought that you would end up in like the Vermont Psychiatric Care Center, or whatever it's called now, the new state hospital, or like Brattleboro, and then you go to the secure residential, River Valley, or you have an ONH, and then you're in the community under supervision. So that's how I understood the mental health component of what we're talking about here, like people whose behavior due to a mental health condition is so dangerous that they need to be contained. I thought we did that in hospitals only. I didn't know we did that in prisons.
Yeah, I think
They're not convicted of something else.
I think that as far as the DMH custody, that's mental illness. So so there could be other reasons that a person is found either incompetent to stand trial that are still mental health related, but not necessarily a mental illness.
Yeah.
And those are the universe of people who might be in a correctional facility now, even after a finding of incompetent. They might be released in the community as well. So that's a possibility. But yeah, that is part of the issue.
Yeah. How many other states in the United States of America treat justice-involved individuals who have not yet been convicted the same way that they're treating those who have been found guilty, like Vermont does, versus like other models like jails versus prisons, or like detention dormitory? You know what I mean? Like, how many other states use this model where we just incarcerate everyone equally, guilty or not?
Well, again, there are other states that do this in a variety of different ways. So some have the Department of Corrections being the state entity that oversees people that come in through the forensic facility process. Other people have it be more of a human services type of agency, like I just happen to have recently been looking at Florida. But and so Florida, no, they do it more of an agency of human services.
Yeah, they do.
Yeah.
Okay.
So that, I just say that happens to be one that I was recently looking at.
Okay.
But there are states that do it both ways. There are some states that have Department of Corrections being the state entity that's overseeing people that come in through the forensic avenue. And there's other states that have it be more of a human services type of agency.
Are those states, do those states house the Department of Corrections in their agency of human services like we do, or is it a separate structure of government in those states?
I don't know the answer to that. Good question. I do know that some of them have DOC as the entity, as I said, but as to whether or not it's sort of, like you said, a standalone or perhaps in a different agency of government, that's a good question. I'm not sure the answer.
Thanks. I don't need to belabor it. Part of this is just trying to understand what I'm trying to understand. Number one, the constitutionality of the practice. Two, more about our current practices in which of corrections in which we're trying to embed this healthcare related, structure of government. And so I just appreciate the details for us to think about.
Yeah, they're important questions to think about in the context of this process, and it sort of circles me around to a point that I didn't make that I meant to at the beginning, which is that this would be a new process in Vermont, a new statutory setup. And although there have been US Supreme Court cases on this, because this system doesn't exist in Vermont, have not been any challenges under the Vermont Constitution to this process, because there couldn't be. We don't have a system. We don't have such a system yet. So the reason I'd like to present that to you is because it's not a question of whether, if this passed, which I'm not saying it would or wouldn't, it's not my job, but whether, if it does, it's not a question of whether it will be challenged constitutionally. It's when. It absolutely will. And if only because if you're a defense attorney, of course, that's, it's an unresolved question of law in Vermont. And in fact, it would be, every defense attorney who had a case like that would have to make that argument. And so the attempt has been to kind of put on as much, include as much process as possible for the off-ramp for a person who's subjected to this commitment to get out. And part of the reason for that, other than it be, views on what you think about whether that's good policy or not, but another reason to do that is because to make it as strong as possible in the constitutional challenge, which will inevitably come.
I have Dave and then Daisy and Karen. Oh, I'm sorry, Brian.
Then you can add me back online
Okay.
if someone doesn't ask me first.
This is like one of those things you ask 3 questions and you have to call back in the queue.
I think it's good to share. Yeah.
From my experience from watching TV, I guess, not guilty by reason of insanity is not often successful. Is that true?
That is true. I think it's far more frequent that the competency issue comes up.
Yeah, it's a trial.
Yeah.
Is there any conflict between victim notifications and HIPAA? Or do they have a right to know anything about a defendant's mental health?
Don't know the answer to that off the top of my head. I know that there are crime-related exceptions in HIPAA. So whether or not it specifically applies, there's another HIPAA exemption that I often mention is the state law HIPAA exemption, which means that basically, if the state passes a law that mandates, not discretionary, but requires disclosure of certain information, then that is also an exemption under HIPAA. So if you had a statute that said such and such information shall be disclosed, then HIPAA won't prevent it from being disclosed. It's called the state law exemption.
Okay. Thank you.
Yeah, thank you.
Karen Barber will know the answer
Know
to
the
that.
answer.
Yeah. I just wanted to say we haven't really talked about healthcare workers in this. And we've talked about the victims, we've talked about the targeted folks at the center of the bill. We've talked a bit about the agencies involved. But I think I thought of the healthcare workers when Brian was talking about where these folks go and appropriateness of setting and it being therapeutic. Right now, I feel like I've heard stories of folks who are dangerous being in a clinical setting and the challenge that is to our healthcare workers. We did that bill last year for workplace safety, and then also just what it does to bed availability when you have someone who needs like a 2-on-1 or a 3-on-1 staff because they have really high needs and they're dangerous. So that came into my mind, that tension between it needing to be a clinical setting if a mental health issue is the main issue with an individual, but if they're dangerous, you can see where the position that puts our healthcare workers in and how there might be a tension between DOC and DMH in terms of placement. And that tension is real. And that's why a lot of folks have made the case that we need a forensic facility that is a combination of both.
Good point.
Yeah, I just wanted, maybe off the top of your head, the site to the Supreme Court case that did rule in some other places, or you could forward it.
Jackson v. Indiana is the competency one. 1976, I think. And it's funny that the competency one is Jackson and the NGRI one is Jones. So sometimes there's a Jackson and a Jones. And I think Jones v. But I can send you the facts for sure. Yeah.
And then this is just a sort of more open question, sort of following up a little bit on Brian. Are folks at all thinking a separate facility, not a correctional facility, would be a better place for folks in this category? That's just an open question. No one needs to answer it now, but
So we can.
I'm wondering about it. Just one.
Am I next?
Yes.
So the question I had was, and you may not know this, but you talked about the inevitability of lawsuits about the constitutional rights of people caught up in the system. And I'm wondering if you knew the approximate range of cost for the average constitutional lawsuit for the state. Like every time the state is sued and goes to court and bears the expense, how many hundreds of thousands, millions, billions of dollars, I don't know, trillions.
I know, that's
Okay. We'll have to ask Nolan or someone.
Yeah, that's right. I was going to suggest someone from the AG's office, but you're right. No one's
The
probably.
JFO might know.
Yeah, for sure.
And then can I respond to what Karen said briefly?
Yes,
Very
let's
briefly.
respond and let's move on because we've had Jack McCullough waiting for.
Oh, yeah, I want to make sure we hear from him. Karen, quickly, I will send you a link to a bill of an alternative to this, where we could build a recovery facility that does many things in one place, including this, that has been given no airtime. That there's like a bill that was introduced that could address this. And so I'll send it to you and then we can talk more later, just because there are alternative possibilities. Thank you.
Leslie,
My
really
questions are just clarification. We're gonna take a straw poll on this. We're never gonna have possession of this bill. Is that what I'm
we're
understanding?
never having possession.
Okay, so there will be a straw poll, but not anything more than that.
Yeah, and we can make recommendations.
Okay, and I'm just curious to know, because I wasn't sure that Katie answered, but maybe you don't know either, what is the healthcare responsibility in thinking about this bill in our committee? And that, of course, your judiciary, I'm not sure I get that. I'm a little stuck.
Yeah, that's probably sort of beyond me. I mean, I think there is treatment provided to the person, so maybe that's kind of the part that's this committee is interested in or has some role
But we're not just saying. no.
Therapeutic setting, thinking about what is a therapeutic setting, what constitutes that, thinking about competency restoration and what it requires, learning about that.
Well, I mean, I think the thing that worries me is that if someone can be sent back to the community, and that worries me for someone who's not competent to stand trial. That's an issue that I don't, but that's Judge Judiciary, that's not us.
You mean the sending the person back to the community service?
Yeah, and what kind of setting are they sent back to the community?
Right. The specifics of it are more, probably going to be related to, because they're going to be under the supervision of the Department of Corrections. I suppose that's probably going to be.
So was that a DA
Corrections.
question then that back to that? Okay,
I think it's a way.
I just need some clarification. Thank you.
Thank you, Eric.
Yes.
Oh, wait, I actually have one.
Yeah.
Have we ever had a forensic facility, like, was the state hospital ever? How did we deal with people when the state hospital was in Waterbury?
I think it was the same process that you're having now, that a person could come in as a result of mental illness, but it wasn't a specific.
It wasn't like a special wing or anything like that?
Oh, well, no, that's a good. There wasn't a forensic facility by name, at least.
Okay.
But I do recall that at the state hospital in Waterbury, they had court right there. That's where they had a courtroom in the building, or a room that they used as a courtroom. And many of these types of cases that come up now and they're not guilty by reason of insanity or competent to stand trial or civil commitment cases were held down there. So
Interesting.
I don't have that option anymore.
We should do a history of the
Yes,
state hospital.
we should do that. We should do the whole like system.
Thank you so much, Eric.
Yeah,
Thanks.
definitely.
Come on upstairs.
Yep. Any other questions that you think of, follow-ups, or any other information that would be helpful, just let me know.
Thank you.
Thank you.
Thank you.
Hi, Jack. If you're still there, if you haven't fallen asleep on us, I apologize profusely for our tardiness today.
Oh, no problem at all. I am still here listening. I was very glad to have the opportunity to listen to what Katie and Eric had to say about this.
Sorry.
We often spend a lot of time in the same room when mental health bills are before the legislature. My name is Jack McCullough. I'm a lawyer at Vermont Legal Aid. I'm the director of the Mental Health Law Project, coming to you from my sister-in-law's dining room in Winchester, Virginia.
Nice.
Yes, it's warmer here than it is up there.
Rub it in, don't rub it
I
in.
know like 4 people in Virginia this week. Everybody went to Virginia.
Well, I'll be back there by Thursday, and I know however cold it's going to be there. Oh, well. So I appreciate the opportunity to be here. I'll try to give my comments on this that are as much as possible limited to what I think are the significant healthcare aspects of the legislation, and to give kind of a higher level view, if keeping in mind the opportunity to answer questions as they come up. In my project, I know I've testified before this committee earlier this session. In my project, we represent all the people that Eric was just talking about. Everybody who comes into an involuntary commitment or hospitalization or non-hospitalization setting, whether through the civil process under Title 18 or through the criminal process under Title 14 or 13. So that includes both people found incompetent to stand trial and people, very, very much smaller number, found not guilty by reason of insanity. And what I can tell you now is that all of those people, under whichever way they come into the system, receive the same kind of treatment. And what they do is they receive treatment that is determined by the clinical personnel at the hospital that is appropriate for their treatment needs. And
I'm sorry, which hospital are we referring to? The state hospital? The
whichever hospital,
psychiatric?
whichever hospital they wind up in, some of those
Okay.
people
Okay.
Psychiatric
up-
hospital.
yeah, any psychiatric hospital. Some people wind up committed to the Vermont Psychiatric Care Hospital. Some people wind up committed to the Brattleboro Retreat or sent to the Brattleboro Retreat or the VPCH for treatment if they're determined at the or some other time to require inpatient treatment. And it could be any of the hospitals, really, any of the psychiatric hospitals. And what
What
happens, I'm sorry, go ahead.
I'm sorry, what other place has level 1 beds or is a psychiatric hospital besides the retreat and VPCH?
One half of the psych unit at Rutland is level 1.
Okay.
And I don't know that UVM has level 1 capacity. I don't think they take level 1 type people. But we represent people at all those hospitals. And one of the things that I know is that under the system as it stands now, if a person is committed to a hospital, and everyone who's committed to a hospital is there because they're determined to have a mental illness, and they're determined that they're a danger to themselves or others, and that they need hospitalization in order to not be a danger to themselves or others. And so that's one of the things that I've heard people say that I just plain don't understand. I hear people say, well, the mental health system doesn't consider public safety. That's not part of their mission. But in fact, the statute is clear that to get to be hospitalized or committed, you need to be determined to be a danger to someone, maybe to yourself, maybe to somebody else. But that seems like a pretty clear connection to public safety. It's not law enforcement type public safety, but it's public safety because the part of the system is to provide people with the psychiatric care they need, and part of it is to do it in a way that prevents them from being a danger to themselves or others. And over the years, we've only been doing the criminal cases for a few years, but even before that, over the years, I've represented a large number of people who have come into the system because of they're being charged with a crime and being found incompetent to stand trial, and they've been treated whatever they needed. And I've certainly known people who really, really want to be found competent to stand trial, and some people wind up being found competent to stand trial. Other people never get found competent to stand trial, but some of the people that I won't go into any names or any specifics, but some of the people that I know you all know about their cases because you've read about them in the paper and seen them on TV. But some of those people, even without a competency restoration program, even without a dedicated forensic facility, some of those people who've been charged with very serious and attention-grabbing crimes wind up being found competent to stand trial, and either going to trial and being convicted, going to trial, being found not guilty by reason of insanity, or entering a plea of guilty. So you may wind up, someone in this position, even without a forensic facility, could wind up going through the trial process and being found guilty of the crime they're charged with. So I really don't. So from that perspective, setting up this new facility, which I assume it'll either be a new building on the site of some one of our correctional facilities or a conversion of some of the space in one of the correctional facilities to this use, I don't see that that's going to serve any purpose beyond what the current system already serves. And for Representative Gina, it's true that there are people in corrections who have been held, pretrial detainees are held in the same facilities as convicted people, and there is a psychiatric facility within Southern State, but I represent people who are treated within the psych unit at Southern State, wind up decompensating to the point where they get sent from there to VPCH and possibly go through commitment process there, possibly stay at VPCH for a while without essentially without saying they want to have their hearing scheduled, and wind up going back to corrections. And it could happen more than once during the time they're being detained there. So yeah, I think that's a serious problem, and it illustrates one of the concerns I have with this, which I'll get to in a little bit. But so the point of my whole recitation of what happens to people now in the system is that we're not seeing any significant number of people who are found incompetent to stand trial or not guilty by reason of insanity, who go through our present process and then go on out and commit another serious crime. It's just from where I sit, I'm not seeing it happening. There are a bunch of questions that just constantly go through my mind in this bill that I really don't get. Like, I don't know what competency restoration services are going to be provided. What is different that they're going to do in this place that they're not already doing for people who are committed to the hospital? Where's the evidence that it's any more effective, or it's effective at all, much less any more effective than what our system does now? And what's the evidence that we have the ability to do it? And as a couple of members have asked, what's the evidence that the best place to provide it is in corrections rather than the Department of Mental Health? Because I don't think most people would say, yeah, Department of Corrections is really the place to get high quality psychiatric care. I don't think that is the case.
I didn't mean to spit out. I actually did have a cough, but it did come out at a time when you were like, you're right. No. I think Brian's got a question real quick.
Great.
If it's a good time, because I don't want to.
Oh, sure.
So it's my understanding, and you can correct me if I'm wrong, that existing statutes require incarcerated individuals to receive equal access to healthcare as if they were in the regular community. But they don't get that. But I remember, I think, I don't want to name names here, but I remember one advocate once saying that was already the law. If I'm wrong, you can correct me. But if I am right, I'm curious if you could comment, or even if I'm wrong, I'm curious if you can comment on how the current correctional setting is taking care of people's, because you just said it's not what people say they want to go for, high quality care. Can you give us an assessment, a brief one, of how they're doing with taking care of people's mental health while they're incarcerated, whether they're detained or sentenced? And what is your confidence in the healthcare contractor WellPath?
Well, I don't think you're wrong. It would take me some research to find that specific provision, but I do think the law requires that people in corrections receive healthcare according to the standard of care that anyone would receive. I don't think they get that in corrections. Just within the past couple of months, my office and I personally have been representing someone who has been in corrections and then in the Brattleboro retreat, and we just negotiated last week a mechanism for having him discharged on conditions of release and bail, but that the records seem to show that every time he comes out of corrections, he's worse than when he went in. And I think that that's probably not an unusual circumstance. So it certainly raises a question about what's going to happen to them, to anyone else who goes into this system. I know I don't want to be critical of WellPath because I don't know enough, but I do think from some of my talks with them and some of what I've heard in cases that I've been involved with, that they don't get to see a psychiatrist very often. The resources probably are not what would be necessary, and that probably shows.
I think Wendy has a question, and I just want to, I need to wrap up by 4 o'clock today. I've learned that we actually may have a little bit more time with this bill. And I know, Jack, you're out of town right now, but maybe back Thursday, so we can continue this conversation with you. But Wendy's got a question.
Quick question. I get what you're saying about this separation, and I understand that this is a unique subgroup of people. I don't think anyone belongs in corrections, especially for mental health, but I also understand the need for safety for the healthcare people. So I don't know where they belong, but I do think that they should be in. I didn't actually like this bill until I started listening to it, that I do think they belong in a separate, I know you don't like that, but a separate entity where I don't know if corrections is the right place, but I do think that they need to be in a place that is secure, and that the people who are taking care of them are safe. I don't know what the answer is, but I know you don't like the DOC, but I don't know if they cannot do it without that. It's like.
Well, what I could say is that there are people, that there are other people in our psychiatric hospitals who are also there because of violent actions that may or may not be charged as crimes, that the population, their treatment needs may not be that different. And so it may not be necessary to have them in a different facility. I can probably be here on Thursday, so I'll just see if I can make a couple of points. And I have a bunch of due process type points that is more judiciary issues than your issues, so I won't go over those.
I'm sort of hoping, and it doesn't have to be today because I want you to visit with your sister, or I was sort of hoping that you could kind of flag for us areas in the bill that we should really be highlighting and paying attention to. And sort of from the lens of where we're being asked to weigh in on the component of how it intersects with Department of Mental Health and our purview over mental health.
Sure. One of the issues is that there is a provision for involuntary medication applications in the Title 18 proceeding. Those are in family division, and one of the benefits is that those hearings are not open to the public, and you're guaranteed that if they're going to be asking for involuntary medication, they're going to be talking a lot about a lot of people's confidential medical information, their psychiatric history, their psychiatric symptoms, what medications they've might have had in the past, what their behavior is in the facility, what they do when they're on medication, a bunch of stuff that really should be in a more confidential setting than a criminal court that's open to the world. And so that's a real concern for us. We're told to expect that this is going to be 6 people. And I assume that means, 6 people a year, but once they get 6 people in, how do we know that they're gonna, once they take in this first 6 people, they'll get them fixed up and ready to go out to their next step within the year, so they have room for the next 6 people? Or are we gonna see 6 people, add 6 people next year, add another 6 people a year after that, until we've got a big and unmanageable size facility that is going to be very, very expensive? I don't know how much it costs a day in a correction facility, but I don't think it's cheap. Well, let's see. I'm pretty concerned about what I would call a slippery slope, which is that right now the bill is set up to address only people with the most serious life sentence crimes, people eligible for hold without bail. But it's predictable that there's going to be pressure to apply this to more and more people. And creating this system is going to give way to that happening in the future. Let me see. So,
You need to fill bed, keep the beds full. Is that?
not only the beds we start out with, but all the new beds that are going to be needed. Oh, and someone asked a question about HIPAA. I think that the way the victim notification works now is people are getting notified that the person's being discharged, but I don't think they're going to be getting any medical information. So I think that'll be the same way. I think there's probably not a HIPAA concern. And so that's where I am. I know we have a few minutes left, so I'd be happy to answer questions.
We have one question from Daisy, and
Jack, thanks so much for joining us. It's really good to hear from you on this. I'm curious, what are other states who don't have a forensic facility doing to support folks who are just as involved and have mental health issues?
Sorry, I don't have the answer to that. I can see what I can find out, but I don't know.
That's okay. I can also do some research, but I'm really curious because we heard from Eric that most states have one, and I'd really like to know, how can we do this right?
Yep.
And in the same vein, I'm wondering if there are other states that do have a forensic facility and are doing it right. That would be,
Yeah, or whatever.
Go ahead, Leslie has a question.
Jack, you were concerned about additive, each year adding more and more. I'm just wondering, is there any look back data that we could have about how many people, like in the last 5 years or something, who might be subject to this kind of, I'm not sure the right language, but who this would apply to, let's say, that being in a facility like this rather than elsewhere. Can we find that out in addressing your slippery slope argument?
Oh, that'd be probably a good question for DMH.
Okay, thank you.
You're welcome.
Jack, we would love to have you back in because I know we cut you short today. So maybe we can reach out for towards the end of the week. That would be terrific.
Sounds great. I'd be happy to come back. I make my schedule work however you need me to.
Thank you. And thanks for joining us
Thank
today.
you so much.
Oh, you're welcome. Good to see you all.
Virginia.
Yes.
Yeah, the blooming trees must be incredible.
And the redistricting vote was today in Virginia. I'm wondering how that's gonna go.
Oh, yeah. Well, it was 30 degrees when I got up this morning in DC, so it's not exactly
Oh.
summertime, although it's about 80.
Very
degrees.
blossom.
Yeah. Okay, thanks, folks.
We'll see you later.
Bye.
All right, everybody, we are done for the day. And we can go off of live. We'll be